They say technology makes our lives easier for work, to learn, to travel, to communicate. But there are things that machines cannot yet do. Things as important as engaging, putting themselves in your shoes, having intuition, or making intelligent decisions. In an increasingly technological world, we need professionals who provide intelligent solutions based on their know-how. Because there are things that technology cannot yet do for you. The human tech.
Good afternoon, everyone. Well, thank you very much for joining us today on the 15th of July. We're really in the middle of the summer already. And I'm sure for those who are listening from Spain, I'm sure you are a bit hot today. Right. It will be great if you could please send us through the chat channel all your questions, because I'm sure this webinar is a very interesting one. I'm sure everyone is different. Everyone has a different option. And we are more than happy to take it later on video conference specific. Today, we're going to talk about general advice. And one of the important things we've been discussing is from the floor, from our clients, is how good is now the option about selling, transferring property, will, donations, selling, obviously as well, annuities as well, like reverse mortgage, having a pension, how good is living in that property and having a pension, an annuity. Okay, we're going to start. Okay, here you have in the chat pretty much the topic. Please feel free to send questions and tell us where you're contacting us from, and probably, if it's brief, specific, in case we could talk general. Later on, we're going to have Michael from South, from Andalusia, and I've got here in the panel Pedro. Hello, Pedro. Can you listen?
Hola, Ignacio. Hello, everyone. Nice to talk to you, and thank you for joining us.
Okay. We're going to have as well, hopefully, Connie from the insurance department. Obviously, as you know, that covers a lot of thinking about being insured as well. That's another possibility. What covers, what cost, ins and outs of all these possibilities that we all need to learn and know. Okay. Now, for those who just join us, we're going to talk. Should you sell your property during your lifetime? Would it be better to transfer it to your children now? Or is it wiser to leave everything through your will? The answer is not always straightforward, as you may think. And today we're going to talk about different possible scenarios. I know Pedro really insists a lot of times when clients talk about donations. I remember Pedro insisting that we need to be very careful with everything we do, because every transaction, everything has a legal consequence, a tax implication, and probably is difficult from a legal point of view, change it in the future. So it's very important, I believe, when we do all this planning, you tell us what are the options that you might consider, what is the relationship with your partners, children, family, and then we could talk about planning and a better life while you are alive. Okay. All right, Pedro, I'm going to pass it over to you. I know we could be talking for ages. I know we are having a lot of clients. And I like to say hello here to a lot of like Barbara, and then Bill as well. We have it here. I'm sure Barbara is with Dick as well, probably. Okay, Pedro, so I'll pass it on to you. and then we're going to start answering all questions that they might have. Over to you, Pedro.
Okay, thank you, Ignacio, and thank you for the spectacular introduction. We are still, as the game yesterday, we are still celebrating the Spanish fantastic victory, and we hopefully will finish that on Sunday. But what I wanted to say about that is that these results do not come by spontaneity, by like naturally, by chance. It becomes because it's been a big preparation during many years. Many of these players they did it from 10, 15 years ago. They've been playing together, many of them, and so it means that they've been planning and making probably right decisions. And I want to join you this in terms of that estate planning. It's not about just about avoiding taxes, or it is just avoiding problems. That obviously is one of the issues that always arises on when we speak about planning. It's a decision that obviously is going to take into the future about consequences, and obviously the situation where you should have done, but now in that time you cannot. It's been said about Ignacio about gift, or about maybe to put properties in ownerships that belongs to children, or maybe what about inheritance, or what about the assets in Spain, or maybe the assets are outside of Spain because the heirs are not in Spain. Or this issue is important to check them, to see if it's correct, what kind of taxes or implication have this. And obviously this webinar, obviously this in general, we will be answering questions to all of you specifically. I'm sure that will be a lot of questions, and I hope we can answer many of them. And but about transferring ownership, it's a question that I think that is the first question that we have put in this subject. It is something that well, we always like to know what is the plan, what is the future plan in the about the client in terms of what is going to do, what is going to leave. I mean, because at the end, transferring the ownership of a property to someone else, there's a children or a spouse or I don't know, a friend. It means that in the future, whenever you want to sell, you're going to need that person to sign that document to receive the money, and obviously it has some tax implications. So transferring a property, for example, and this is one very good example. Okay, I'm going to transfer the property into the name of my children because whatever in the future, they will be paying less inheritance. It will be paid less inheritance tax because the ownership is in the name of my children. Well, normally this is I do not recommend that in 99% of situations. In many areas of Spain right now, inheritance tax in many areas in Spain is reduced drastically. Is reduced to, for example, where we live in Valencia region, is reduced 99% of the tax to pay. So at the end, you are not really avoiding a tax. You are really transferring some ownership to children, where at the end you will not be able to have a really the disposal. You will not be secured in terms of, well, I want to sell it, I want to buy another thing, or all these issues is we normally we do not recommend to do that. And then arises the question, then we will be answering the question, then arises the question, well, what if I obviously write a will in Spain in order to make a plan on this? Obviously it's fully recommended. Sometimes it's not a must, it's not something that is relevant in terms of law, but many cases we recommend it. For example, someone has a will in the US or in the UK or in the Netherlands or Norway, or in many countries, and then they bought a property in Spain. If you are non-resident, you just bought a property in Spain just for like a holiday home or second home, and come sometimes to Spain, maybe half of a year, you do not really become resident, you do not really become tax resident. Well, according to Spanish law and according to attracting to European law as well, the law apply to that maybe future deceased will be the national law of the person who has died and is the owner of a property. So at the end, will not be attracted to Spanish law because in Spanish law we have like a legitimas, which is like it's like a provisional positional law where the children has the preference and has the right to receive at least 2/3 of the assets. Which means, for example, I always say my example. I'm married, I have 2 children, and obviously I live here in Spain, I'm resident in Spain, I'm tax resident in Spain. I cannot give all of my assets to my wife. I repeat it. I cannot give all of my assets to my wife because 2/3 of my assets goes to my children. This is in general. But think about that. So whenever someone comes to Spain and lives in Spain, is attracted to Spanish law. But I started with an example that if you are non-resident and you bought a property, it's perfect because, I mean, you have a will made in the US, in any country, and a will which obviously covers all the worldwide assets. Perfect. And well, will be a national law to be applied. Then will be a public document that says, with a testament or with a court, which says the heirs, the beneficiaries of that will, of that assets is this one, this one, this one, and then obviously in Spain we can manage with those documents and transfer the ownership to those heirs. Perfect. But what if you become resident? And probably many of you are residents in Spain. Well, if you become resident, first thing, do you have a will in Spain made? Maybe not. Maybe you have a will made in some country. But have you specified, clearly specified, that you want your national law to be applied in your in order to choose your beneficiaries? This is not really Spanish law, it's really European Union law, where there are 3 countries that are, well, there are now 2 countries that are now included here. It was before UK, Denmark, and Ireland. Now UK, obviously, because of the Brexit, is outside. But this European law, which is, I will write it down, 650-2012, it has 2 articles, Article 21 and Article 22. Article 21, it says, basically, if you live in one country in Europe, then the law to be applied accordingly in order to choose your beneficiary is a national law where you are resident. So if you are from Nigeria, if you are from Japan, if you are from France, if you are from US and live in Spain and you have not said anything about who is the law applied to your heirs, who is going to be your heirs, then will be a Spanish law, for sure. That will be attracted to Spanish law, according to European law rules. So it's a must if you want to avoid this 2/3 of the children and legitimas, like obligation to be given to the children. If you want to avoid that, and in this case, as an example, to give it to your wife or wife to the husband or someone else, then you need to expressly decide and say, well, I want to be applied to my national law. Obviously, you need to know what says your national law. What if you are Italian, if you are from Norway, you are from Sweden, I mean, you live in Spain. It's the same if I live in France, if I live in Germany, if I go to Italy, I will have to, in some way, prove and say, make in a will, a testament, or that I want to be applied my national law, which is Spanish law, in case I want to decide my Spanish law and not Italian or Germany or wherever, if I live in those countries. Okay, having said that, so it is important that if you move to Spain, to have a will. If you do not, maybe many of you are non-residents and have a will in Spain as well, a will that covers all the worldwide assets except Spain. That also it is compatible. But I always say to clients, it is compatible, and this is from my experience and from court litigations and this, it is compatible if it says really the same. Just to do things straightforward into transferring the ownership from the deceased person to the heirs, to the beneficiaries, is very rapid to deal with a will in Spain, very rapid and easy, and well, it's very straightforward, just for the Spanish assets. And if I'm living in Spain, well, I have a property in Spain, I have some bank accounts, some investments outside of Spain in different parts of the world. What if my heirs are not resident in Spain? What if they are living abroad? Well, I like to explain this situation where with examples. Imagine that you are living from US citizen that lives in Spain, have some investments made in the US, and the beneficiaries, the heirs, are in the US, and this person lives in Spain and dies in Spain. Obviously, the assets that are in the US is the resident is who is going to receive the assets. It also lives in the US. That is something that Spain will not take into account. Spain will not, because at the end is the one who lives in the US has to declare whatever is being given by the person who, in this case, dies, with a testament made in Spain that says that you are going to receive 1/3 or 1/2 or totally whatever, and these are the assets, and we have to be declared in the US because as well the assets are in the US. Also could be also receiving an asset that is in Spain. Any asset that is in Spain has to be also in some way declared into the tax office as well. So someone lives in this case in the US at the end, and the assets are in the US, but nothing to say. If someone lives in the US, but the property is in Spain, and this is one of the questions, for example, that could be made, well, obviously that property, depending on the area in Spain that is, it will be transferred into the ownership of the heirs, according to the will made in Spain, or maybe a will made somewhere else, but obviously valid in Spain, and will have to be taken into account about taxes. Taxes in terms of the properties in Valencia region. Okay, in Valencia region we have a lot of benefits, 100,000 euros threshold, then we have 150,000 euros about the main home, permanent home, and we have once the property has been balanced and valued, then it's reduced 99%. I mean, there are some issues that obviously will be, even though the beneficiary is non-resident, will have these those benefits. But depending on the area that the property or the assets are located in Spain, will be some tax or not. It will be something about that. Ignacio, you want to participate? For me, it's okay.
Yes,
about
okay,
this.
Pedro. I don't know if you're finished, but I would like to then
Yeah, I mean,
introduce.
yes. Go ahead.
Yeah, okay. Basically, I would like to introduce here Michael. Michael just arrived. The microphone, Michael, is off. And I think your email address is still pending to put here. Michael Davis
Good
is from
afternoon,
Davis
everyone.
Solicitors.
Hola, Michael. How are you doing?
Hello.
How are you, Michael?
Very well, thank you. I was at the Sting. I was in the Sting concert in Fuengirola last night. So no, sorry, I'm losing track now. On Monday night, I'm still getting over it. Very good. It was excellent.
Right. Okay. And here we have Connie from the insurance department. Hello, Connie. Can you listen, or you are not able? The microphone is off. Yeah. Okay. Right. What we try to do here is just, Michael, do a brainstorm a little bit, because a lot of clients are always, I'm sure, because of your practice, you've been more than 25 years already listening about, should they sell the property? Would it be better to transfer to the children? Is it wiser to live it through your will? Obviously, the will, we always say, is a must, but it's not a must because the law, because Pedro said, is not compulsory. But you would not imagine how many problems you could have if you don't have a will. So, Michael, could you please give us a little bit of background from your expertise?
Yeah, absolutely. Okay, so for those that don't know me, my name is Michael Davis. I'm a lawyer here down the Costa del Sol, and I deal mainly with inheritance work all over Spain, including the islands, since 1994. So we've handled quite a few inheritance cases. So the number one. I don't know what things Pedro's already covered, but basically sort of a quick sky view would be the first thing is that for foreigners that buy a property in Spain, it's very important to make a will in reference to the Spanish estate. It just keeps things much simpler, because otherwise later on, if I'm handling the inheritance, I've got to convalidate the will that you may have done in the UK, in Australia, Canada, etc. And it can cause lots of problems because the laws are very different. So over there, you may have mentioned a trust that don't exist in Spain. There are different variations, things, and also that nobody would have been able to advise you correctly about inheritance tax in Spain if you've gone and done a will in the UK for worldwide assets. So that's the first thing I would do. I've seen from the email that you sent out to all the clients, one of the things is what happens if like a client comes in and they're trying to plan whether they want to, they're getting on, they've got their will in Spain, so that's going good order, but they're sort of thinking, well, maybe we should pass the property on during our lifetime to our kids and not wait. So let me just give you a quick few pros and cons, and this really does need individualized information. But let me just say from experience, some of the sort of pitfalls that exist in these sort of plannings when they're not done correctly. So the first thing is, I like what Pedro says, that in general they're against donation to kids of assets during their lifetime. I am as well, but absolutely, I've seen it happen many times before. People leave their villa down in Marbella to their kids, and from that moment on, they see their grandchildren much less. So we'll put that to one side. That's something to think about, which is it is absolutely true. I've seen it happen many times. So, do you donate or will you inherit? Okay. The inheritance in the old days, when inheritance tax was very high, there's a lot of thing about avoiding inheritance tax. Nowadays, both in Andalusia, where I work, and in the Valencia region, where Ignacio and Pedro work, inheritance tax for Group 1 and 2 beneficiaries is not important. In other words, because children, spouse, and parent in Andalusia get the first €1,000,000 tax-free and a 99% discount on the rest. And in the Valencia region, you get a 99% discount on everything with certain exempt amounts at the beginning. So in other words, the inheritance tax is not an issue. Now, on the back of that, donation tax is also very low. In Andalusia, it's extremely low. You get 99% discount. I think it's very low up in the Valencia region now as well, also with a very large discount. Now, where I've seen terrible mistakes is people donating during their lifetime without taking into account the underlying capital gains tax. So let me just give you a little example of this. And I've seen this error. I know it sounds crazy. I've seen it many times. I've seen it probably 7 or 8 times just in the last 2 years. So because donation tax was brought down substantially, and then at the end, I'll explain why in some cases the donation can be worthwhile, and it has to do with English inheritance tax, not with Spanish. I'll explain that at the end, which is actually very important as well. So basically, if you donate now, let's say you've got a villa in Spain and it's worth, €500,000, but you purchased it many years ago for 120. It's not your main home. If you donate it, the donation tax to the person receiving the property is basically nothing. So it's not even worth talking about because of the large deductions. But what people forget is that in Spain, if I donate a property, I can't assign to the property whatever value I like. There's a system of benchmark values. So let's say that on that property of 500,000, the benchmark value is that, or maybe a little less, 400 or whatever. I donate it to the buyer. The solicitor handles a donation deed. It has some formalities. He's given you the budget of all the different taxes and fees, but he's forgotten to say that in a few months' time, the person that's donated the property, the parent, is going to receive a large bill for capital gains tax. And you say, well, how can that be if you haven't actually received any money? It doesn't matter. The person that acquires the property is allowed to step up in value. Their new starting price for capital gains tax is the 400,000. But in your case, you'll receive a bill of between 19 and 24% of the distance between the 400,000 for which you're donating it and the 100-something thousand that you received the property for many years ago. So if you decide on the donation, and I'll explain where there can be an advantage for that in a second, if you decide on the donation, you do need to make sure that your solicitor explains really well, make sure they've taken into account what your potential capital gains tax liability is on the donation, which can sometimes be a very substantial amount of money on these properties that were, if of course you're over 65 and you're resident, there can be cases where there's no capital gains tax. Just make sure you speak to the solicitor about capital gains tax. Ignacio, I've lost you. Can you hear me? Can you hear me? Pedro, can you hear me?
Yes, I can hear you, Michael.
Okay, I just couldn't see you on the screen. Okay,
right.
So where do we start thinking donation and when it can work, etc. Well, there's 2 situations. One is if you've got sort of someone that's got a load of assets, say in the Costa del Sol, they've got like, 4 million euro, they've got 10 different assets, etc., and they say, Michael, but what happens if inheritance tax goes up in the future? Because of course it can change. We've had 3 changes in the last 10 years. So what happens? So they say, well, I'd really like to hedge my bets. I'd like to donate something now to basically tie in the low donation tax, low inheritance tax that you've got now. Because otherwise, if it changes in the future, I could be close. Because back in the days, there was very high inheritance tax here in Andalusia. So with that, we sort of go through we typically go through their properties and see which one of the properties has got a very low underlying capital gains tax because they bought it for a more expensive price. They bought it more recently. And so that you could donate that one, and that one. That would cost you close to nothing and keep the rest. That's one of the situations. The other one is inheritance tax in the UK. And where does that come into play? Well, if you're in Spain, it's the beneficiary that pays inheritance tax. So if you're receiving an asset from your parent in Spain, in Andalusia, you'll pay almost no inheritance tax in Spain. But if your father is domiciled in the UK, you'll be paying inheritance tax on worldwide assets. So if you're over the threshold, there could be an advantage in donating the asset in Spain so that if you survive the 7 years, then the asset is not brought in and added to the assets in the UK. So with this, what I'm trying to say is, in reality, it's a complex matter. It can't be oversimplified, and we do see people that have jumped into things. And if there's just, as my granny used to say, who's British, a little bit of knowledge can do a lot of harm. Well, we've seen that. If you're in doubt, don't do the transaction. But if you look into it carefully, sometimes it can really be worthwhile to do that donation, both to hedge against future changes in inheritance tax. And also to do with the inheritance tax in the UK, which obviously would only be the case if the deceased is going to be domiciled in the UK at the time of death. So there's a lot of different sort of trade-offs with all this.
Michael, I really think it is very important for those of these clients and the audience that is listening, for them to do proper tax simulation with their professionals, with their accountants, their lawyers, and put on the table different possible scenarios. For example, what if I sell the property now? Because as you said, the subject is very complex and not everyone is the same for it, It's just different emotions about different wills, different taxation as well.
Yeah,
it's not the same.
also, I mean, there are so many different ingredients in that. It's well brought up because, for example, it could be a case where, for example, the parents are living here and they're both 70, they're residents, and therefore they could actually sell their property free of capital gains tax.
That's what I was
While
thinking,
their children may be non-residents, and later they will have capital. So there are lots and lots of different sort of variables. So the tax situation is complex and sort of needs individualized advice. And then the other thing that people are getting very, very confused on, like I can see why on the internet. I think Bill's touched it on this as well. And that is when people listen about this choice of law. Well, I hear you can make a choice of law. Okay, so there's 2 different things. One is the distribution of the estate, and the other thing is inheritance tax. And the choice of law has got nothing to do with inheritance tax and just everything to do with what you can do with your estate. So English people from England, from Australia, from Canada, they can basically make their will in Spain, choose their national law to determine how they can distribute their estate. And with that, they can leave everything to their spouses like they do in their home country on the first step and second step down to the children. Because as Pedro says, in Spain, Spanish people can't do that because they've got to leave 2/3 of their estate down. But foreigners are allowed to escape from that system. If they don't escape, and this is another reason to make a Spanish will, people forget that, well, if I intestate, I'm here with my wife and I've got a kid or 2. But basically what they don't realize is that if you are intestate in Spain, Spain's going to apply the law of the last residency to the distribution of the assets. And under Spanish law, the lion's share goes to the children, not to the spouse, like in those countries. So you can end up in a situation where assets are not going to who you thought they would end up going to. So I think it's more of a reason, basically, to get that will done as soon as you've purchased the property.
Michael, let me just add a few ingredients as well. Obviously, nobody's the same. but I really think we could always find a formula or the best formula for each individual to minimize the impact and according to the wishes. For example, you brought a very good point. If you're resident in Spain, you're over 65, and then there is no capital gain tax, that's excellent. That's excellent. That's a very good tax scenario. A different thing is about working out today what is the inheritance tax as well. You said as well that these could change, and that's really important. For those who do not have children, or probably they have in the US, let's put it this way, a trust. There is a very famous thing here in the US about the trust in the UK as well. And a lot of Americans clients have a trust, and they do have a separate will for Spain. Okay, but we could work out what is best here according to the children you have, the allowances, or if you don't have even children, probably you could organize a reverse mortgage, have a pension, the rest the executor they're going to pay into charity. So I really think that there is a big variety of scenarios. I don't know whether Pedro wants to add anything here on this dialogue that we are
Yes,
getting.
I mean, obviously we can speak about, I mean, all this and just touching down a little bit, we were comparing about, I mean, is the gift as the capital gains that you may get if you donate something to someone. When we simulate that scenario and simulation on inheritance tax, obviously when the heirs, they receive the assets and inheritance tax in some regions like Andalusia or Valencia, where the inheritance tax is not an issue, it's really low, it's reduced 99%. And they may, for example, on a property, on a real estate property, they put the value of the property according to the market value because the heirs, they want to sell it. So they receive the ownership of the property as an inheritance. They pay a very few amount of tax on inheritance tax. They put the value correctly in the market value, and they sell it, and they don't have any capital gain selling it, so they have a full amount. So all these scenarios are done with some plan, obviously in the past. And about you were saying about nothing about the wills, is that right?
Yes, very important.
It's extremely important about a will made, and we always say when there's, I mean, I can see there is some questions about will, and we will cover those ones. One of the rules I always inform and recommend to clients whenever they may want to make have two wills, one will in Spain for Spanish assets, rights, shares, and the other will maybe for worldwide assets, just to have in Spanish it's like unidad, is like it has to be the same issue, so no one can make some injunctions, maybe some claims on this will, and this will is not the same, if the national law is not the same one in the United States and in Spain, for example. So you cannot make any issue on the litigation. It is just to make a will in Spain. We recommend it a lot. But obviously when circumstances are correct.
We're talking about an interesting thing I forgot to mention. For those who are below 65, okay, and is second property, okay, do you remember, Pedro, we talk about the annuity?
Yeah, the
That's
annuities.
a very interesting thing. I mean, I know we're talking about a lot of things, but everyone is different. For example, let's think about selling a second property and you doing a strategy to convert into an annuity, and then your beneficiaries will be named there as well. So you will not pay capital gain tax. You'll have an annuity, you'll have that income, and the beneficiaries will receive whatever money is left. That's a possibility as well to avoid. Then some people are getting confused here in the chat, and we're going to jump into the questions and answers. Remember, if you made a will, your rule, I mean, double check your will, but if you dealt through with us or Michael, all our wills are mentioning here that you use your personal law.
One thing. Sorry, one thing. So what people do need to do is, if they made their will before 2014, then they do need to make a will, because if it was before that date, there are many wills out there that don't have the choice of law, because obviously that Directive 650/2012 gave everyone those 2 years to adapt the wills. And if people didn't find out about it because they lost contact with their solicitors, I know back in the days, the Law Society was telling all their solicitors to contact all their clients to basically make the choice of law on the will after that directive was passed. But sometimes there are still wills from before 2014 and definitely from 2012. They don't have the choice of law in the will. So those people need to have a look at their will to see what the choice of law was done.
I agree. The first piece of advice, Michael, I will give to people: number one, just double check today whether you made a will or not, and whether it is updated according to what Michael stated. You have the possibility of choose your applicable law, okay, unless you're Spanish, but probably most of you are non-Spanish nationals, and therefore you have that possibility. That will rule the distribution of assets. A different thing will be whether you are liable, or there will be your beneficiary will be liable to pay inheritance tax, depending on the areas where the assets are and residency. For example, you're in Andalusia, you are privileged, now is very good. You're in Comunidad Valenciana, is very, very good as well. But as Michael said, if you have assets abroad in the UK and the assets are in the UK, even though Spain will not tax, we have a dual taxation treaty. But if the assets are related and located in the UK, the state will pay that tax, which will offset whatever tax you pay here, but it makes things more complex. And now every year is different, Michael and Pedro, because the law changed. That's why it's important to look through the best scenario, isn't it? Because what is good today is not good tomorrow, isn't it?
Let me just explain something for the viewers, because otherwise, if you start looking online, you're all going to get very confused. Let me just explain how the overall picture is of inheritance tax and how it works. So in Spain, we've got 17 different regions, okay? And in Spain, inheritance tax is collected by the regions and not by the state, okay? So 17 regions, Andalusia, Valencia. Now, each region is allowed to set their own levels of inheritance tax, their own set of exemptions. So there's always been a competition between the regions to attract investors in the form of exemptions for inheritance tax. So the thing is, I'm saying this because people then go online and they start looking online. They say this doesn't make sense with what these people are saying on things. So basically, we've got 17 different regions, each one the different levels of inheritance tax. Now, also, on average, the 17 regions have changed their inheritance tax exemption rates 3 times over the last 10 years. So there's a lot of variables here. You have to look at the date on the website. Now, to make things even more complex, one thing is jurisdiction and one thing is legislation that's applicable. So let me explain. If you're a beneficiary and you're resident in the Andalusia region, you will present your inheritance tax return to the Valencia region by self-assessment and claim the regional exemptions. Very easy, because on the form it explains all the region. But to make things more complicated, if you are a non-resident beneficiary, you actually present your self-assessment inheritance tax to the National Tax Office, but by law, you're allowed to claim the exemptions that are available in the region of Spain where the majority of the assets are situated. So it's very easy to get things wrong, especially if you're a non-resident. Why? Because you're actually using the forms from the National Tax Office. It doesn't have all the different exemptions available in each one of the regions. You've got to work out, well, my region is my estate is all in Estepona, therefore that's Andalusia. The exemption levels there are much more beneficial than the National Tax Office level, and therefore I choose those exemptions, and you have to claim them on the forms that you present to the National Tax Office. I'm just saying this because all the time we're having appointments where people are asking us this. we've got to know where the assets are, where the residents or non-residents. There's a lot of variables, and therefore, if you look online, you may be up in Denia, and you're looking online at a website at someone that says he's an expert in inheritance, which he may well be, but he may be based in, I don't know, he may be based in the Balearics, and you're looking at his website, and he may be a lawyer that only deals with things in the Balearics. So you're looking at all the exemptions from his point of view without checking out whether it applies to you or not. So people do need to be very careful when they look online to not get too confused with all this. And also, if you ask an AI, you've got to make sure you give him all the information correctly so that it gives you the correct answer to your region and to your situation, resident, non-resident, etc.
I mean, after what we've discussed, obviously, it's a very personal decision. And sometimes when we do all these consultations, we really need to look into the specific, like your life, your family, your future, your plans, the law applicable at the time. We need to do a lot of questions to be able to advise you specifically what will be the best if you decide to make a move now. Because what is good now, it might not be good tomorrow, and especially inheritance taxes. But we could always analyze, and that's why it's very good to do proper simulation specific, what is best for you to learn now, and what options you have, ins and out, best case scenarios, worst case scenarios. A lot of times, transferring or buying a property, when you buy the life interest and your children have the legal ownership, that's another formula. You've got the right to live in the property forever. They already own the property. That's another formula when you do the investment. But if you already made an investment, what can you do? Oh, do I have children? No. Okay. Do I want to have like a pension? Yes. Probably I could mortgage it and have the reverse mortgage on it. Or do I want to sell my second-hand property and convert into an annuity? That's another option. But definitely what is certain here, and I'm sure that Michael, Pedro Michael will agree, making a will could only benefit you, could only help you, and could only help to leave things as you wish. That's definitely. Okay. So for those who made a will, I will suggest you to double check. For those who you haven't, you could do an international will or even a national will. Some people, and this is reasonable, do one in their home country, one in Spain. And depending on the scenarios, the executors will do whatever you have instructed. Michael, Pedro, shall we jump into questions? Because we're having a lot of them and we're going to run out of time. Before we go, I'm going to introduce Connie. Connie is in the office. She's working from Upfront Insurance, probably life insurance, or related to reverse mortgage and things like that. I don't know if you're able to say just a few words to introduce yourself, Connie, if you want. And if people have questions, they could email you, yeah? Now we're not able to listen. It doesn't work. No. Okay, Connie, we're not able to listen to you. If you want, just drop a message here through the chat. And if people have specific questions about insurance or equity release or annuities, you're able to guide them through.
Can you hear me now?
Yes. Yes, now.
Hello.
Okay, Connie.
Sorry
yes.
about that. I'm having some technical issues.
Okay.
Yeah, so hello everybody. I'm Connie, and some of you may already know me from the Immigration Department. Well, since we've opened our own MAPFRE office, I'm now in this department. So if anybody needs to contact me, you have my email address just there under my name, and you can contact me for anything regarding insurance, financial planning, investments, and I can we can set up a meeting. So either with myself or Ignacio, Pedro, any one of our other advisors, depending on the need. So yes, if anybody needs some help to go over their current insurances, I can go over everything with you, and we can see if we can improve your current coverage, and we can take it from there. But yes, as Ignacio said, our most common policies at the moment, we have the typical home insurance, car insurance, life insurance. There are so many different products that we could be here all afternoon telling you about them. But what I would like to do in our next webinar is to be able to go into more detail about each product, the most common ones. We've got some really interesting ones, especially for our clients, as we now have products specific for over 55s, such as the life insurance. We also have a long-term care plan, which offers some really good additional benefits, as well as funeral plans. Just a wide range, travel insurance. So unfortunately, I haven't got enough time to go into detail about each of them, but in our next webinar, I would definitely like to do that and hopefully arrange some meetings with you, and we can do this complimentary and talk about what maybe if you're missing something, but it's just something I'll go through with you, because, well, we can go over it in English, and hopefully we'll be able to help you improve on that side.
Okay, Connie, I think it will be interesting to learn a bit more, and I particularly don't know possibilities, because some clients ask for the next webinar or for next time about life insurance for people over 65. Some people are worried because they don't know. They want to cover the inheritance tax, because as we said to Michael and Pedro, we really don't know. Today is very good at scenario, but we don't know in 20 years. Some people like to prevent or put money aside or have like an insurance. It might be worth next time talking about what possibilities do I have to cover eventualities in case I pass away. How could I protect X? That will be quite interesting. I'm going to jump, sorry, Connie, to go in a rush. I'm going to jump into with Pedro and Michael now, because if you would like to share your email here with everyone, if they have a specific, you could organize a different day consultation. But Pedro, would you like to start and pick the one that you went through? Because we're having hundreds of questions here.
Yeah, I will start and will be a little bit rapid. If the answer is not clear, please just write down. Okay, so this is by John. He's 80 years old, living in Spain as a resident with some relatives, brothers, also over 65. And he's thinking about selling the property and renting it, renting another one, an alternative home, while still active and with good health. Okay, if you are over 65 years old, and also the second condition is you've been living in the property at least 3 years as a permanent home, then if you sell the property as a resident in Spain, obviously, there is no capital gains tax. So there is no tax to pay on the gain. You sell the property and there is no tax, it's exempt. If the question is about, okay, I have my relatives, I have no children, and what are they going to receive the property, or maybe it's better to me to sell the property and maybe the cash, whatever is left, just to give it to them. Well, important issues you have, in my opinion, you should have a will, obviously organized, a real estate planning to be sure that your relatives, your brothers will receive it as a substitution, many others, or whatever you decide, but a will or estate planning on that. And it's not an issue if you sell the property or not. I mean, the property will be transferred to the heirs that you decide in the will. And if not, it will be the money that is in the bank account that will be also given to the heirs as well. So it is just that. This is by John, different John. If I transfer the title of my property before we die to my children, do we need any numbers and register? Well, we have spoken about that. Yes, transferring ownership. Be careful about the gift, about the capital gains that you may incur, about all these issues. Is extremely important to be sure that if it's maybe it's not needed to do it, but because of the circumstances, if I were explaining to you. But in any inheritance or gift, when it's a property in this case, in Spain, you need an NI number. But when you make a will and you decide who are the heirs or beneficiaries, that maybe one is in Australia, the other one is in Japan, or you don't need to apply for the NI number now. I mean, it will happen in the future whenever you live. And it will be, there are some process to power of attorney and these issues in order to get the NI number because it's needed in the future. But even though it cannot be done, cannot be applied now. It has to be done whenever something happens. Michael, if you want to get some questions, let's go ahead.
Yeah.
I will take in them.
Yeah. Okay. So I'll give you this timestamp so you can follow me through. So on the 1805, someone's saying, if I own a property 50-50, the 50% of the dying party estate would be 2/3 would go to children, only 1/3 to the spouse. Okay, so of course, so in other words, if a couple in Spain have a jointly owned property and one of them passes away, the estate obviously only consists of that 50%. So obviously, when we talk about the 2/3, 1/3, we are talking about respect to her half. So in other words, if he passes away first, and the wife had the one half or the half she owns, nobody touches that. With respect to the other half is what we do this distribution 2/3, 1/3. I just want to clarify, just so that it's clear, when we say 2/3, 1/3, we are simplifying. Okay, in other words, when children compete with spouse, they don't receive exactly 2/3. It's 2/3, but there's an allowance for life possession in favour of the spouse, etc. So it's not exactly 2/3, but for purpose of explanation, it works. It works well. Then this other question, which is sort of in line, I think, with that one, says, just to clarify, my Spanish husband has to follow Spanish inheritance law, and our children will receive 2/3. However, as I'm Canadian, I can choose how I want to distribute my holiday. Exactly. In other words, if they're a couple, and he's Spanish and you're Canadian, your husband has got all the limitations of Spanish law. So when he makes his will, he's got to respect the Spanish system of obligatory heirs, which basically means that roughly 2/3, a little less than that, have to go down towards the children, while you as a Canadian can choose your own national law and therefore leave everything to your spouse with the children as the second step, which I agree, as some people are telling me in the chat now, that seems quite unfair, but that is the situation. In other words, if you have another nationality that does permit you to leave everything to your spouse, and your spouse is a Spanish national, they're going to have to leave assets direct to their children, which it sounds even unfairer in the case of second marriages. So just imagine you're a second marriage, you buy a villa down in Estepona with your new spouse, and he happens to be a Spanish person, has got 2 kids from a previous marriage. Yes, even if he doesn't want to, he has to leave the corresponding obligatory heir share to his own children. As you can well imagine, these sort of situations do cause problems in the future. Yeah.
Okay, Pedro, just carry on, because
about this, well, just rapid one. I mean,
Yes.
gift tax is, says Stephen, the gift tax is reduced in many regions. My question is apart from gift tax subject to capital gains tax. We have already answered that. Is yes. I mean, depending on whatever is acquired, the value, and depending when it's given, give that value. And it says the word plusvalía. Plusvalía is a tax that is paid. It's plusvalía in Spanish is like capital gain, but it's a tax that you pay whenever you transfer the real estate, the property in any municipality. Normally with inheritance, is reduced. This is faculty from the municipality to decide is reduced 80%, 85%, 90%, or maybe not reduced, but not with the gift. With the gift, it's not reduced, and you have to pay also the municipality. In many, I would say, many occasions. I haven't seen it reduced. Maybe some municipalities reduced, but I haven't seen it. Let's go ahead with some.
I've got a good one here. If you so says I've remarried a much younger lady and bought myself a villa down in Estepona. I love her dearly, but not enough to put the property in joint names. So he's put the property completely. He's basically said he's put his property, and I've seen this in reality. I'm sure you would as well. Sort of situation. So the property, he's put it completely in his name. And now he wants to secure the position of his wife, but at the same time wants to be fair for his adult children from his previous marriage. So, and he wants to know whether he can set up a trust. Okay, well, you can't set up a trust. That would be a disaster. And if you try and do it in your home country in respect to Spanish property, even worse. So in Spain, there's a really good solution to this situation. And that is you play with a thing called usufructo, which is called life possession. In Spain, we can artificially divide what you know as ownership in 2 parts: the possession and the residual value, the final ownership. So what you would do, or some variation of this, because various variations of it, but basically what you'd want to do in a situation like this is you'd leave the life possession of that villa to your second wife. That means that she's going to be allowed, once you pass away, to live in the property until she passes away, or to rent it out, anything that's to do with possession. But the ownership, the final ownership, which in Spain is called nuda propiedad, or new property, is to go directly on your death down to the kids. So what happens is that they get a title deed and it gets registered in their name, but with a limitation in favor of the spouse, where she's got the sole right to live in that property and enjoy the property until she passes away. So a combination that we like a lot is, for example, the life possession of the villa would go to the spouse, together maybe with some money that's in the bank account, but we leave the residual value of the real estate directly down to the kids. It means that if she remarries or does anything like that, at the end of the day, she could never leave the kids out. Because amongst other things, and this has a very easy sell from an inheritance, from a tax point of view, because these are very delicate situations, obviously, and that is that it can really easily explain to her, in this case, that doing it the other way, in other words, leaving everything to her and trust her to leave the asset eventually in the will to his kids. It's not just a question of trust, it's also a question of that the inheritance tax bill would be tremendous if we did it that way. Why? She's the spouse, she will receive from her husband with almost no inheritance tax to be paid. But if later on she passes away and leaves that villa in the will to the children, to her husband's children, they're in group 3, descendants by affinity, and they pay a tremendous amount of inheritance tax. So this solution that we're mentioning, or there are various variations of it that we to individualize to a specific case, but this solution is a solution that we like a lot and we use all the time when there are children from other marriages. This or some variation of it. The life possessions, residual values, that you'll read on the internet as a word called usufructo. That something doesn't really exist in the UK, but here it's used all the time, and there's nothing strange about it. It's not complex. It's just a usual way of estate planning over here.
Michael, let me just add one more thing here. I think it's excellent what you just mentioned about usufructo, but I think we have some more questions. I don't know, Michael, if you have any other to run through, or Pedro, because I would like to.
There's so many, but lots of them are very, very specific, so they're not going to be very useful for the rest.
Let me go to some of them.
Yeah,
I fully agree with Michael about it's been usufructo. That is probably the perfect way to. There are some other issues like fideicomiso, like but I think usufructo is fantastic, really. In this kind of, in this case, it's been explained. Okay, by David, I'm 64, wife 63. I assume is living in Spain. They say whenever 70 years old, they want to sell the property and leave the money to them. I mean, as I said before, over 65, and you believe in Spain, in that property, specific property, more than 3 years, you sell the property and there is no capital gains. You get the money, you sell it, you get the money, and then you do whatever you want with that money. If you give it, will be according to your gift tax. According to the rules of gift tax, in this case, in Spain or in the UK, whoever is a beneficiary. So it's perfect. In that case, you can sell the property after 65 years old, over 3 years living in that property as a main home, no taxes. So we are tax resident here in Spain, and with a willingness to US and a will made in Spain. Okay, well, as I said, in my opinion, and this is personal opinion, if the will is in the US, another will in Spain, the will in Spain is for Spanish assets, in order to go straight forward with the Spanish assets. And those wills are not incompatible in terms of deciding who are the heirs, deciding who are the beneficiaries. And if there is some legacies or some issues and the wills are like a mirror, then I don't see any problem. And when I say about problems, is I say if some beneficiary that is not on the will or a legal beneficiary may go to the court and say, I have a right on that. Michael has said an example. You are married with someone, has children, and then you're married with someone else who has another children, different from the children from different spouses. The choice of law is extremely important on these cases, because maybe sometimes the consequences are not the same. So it's something that it is important in the will to at the end to do it correctly, to do it right, and to know which is the law is going to be applied on this.
Pedro, before you go, we didn't mention here something I know we're running out of time, but we are so excited about so many things to share. But important as well when you make will for those of you who are partners but not legally married. Okay, if you're thinking about inheritance tax, okay, I don't know if you did cover that as well. Registering yourself, partnership doesn't need to be getting married. You do it through the town hall or through the notary office. That because Michael mentioned the inheritance tax for those who are not relatives, and you will be surprised how much money you'll end up paying. Is a high, it could go from 7% to 37%, if I recall, uh, of an a variable amount. So I'm sure a lot of people have been living together, never married, never partners, legally partners, but this is something important, protecting each other. So I'm going to pass over to you for your last things, even though nobody wants to leave the webinar today, but I think we need to finish up very soon, Pedro.
Okay, yes, last one I can read right now from Nigel. A resident has made Model 720 in order to inform the tax office about assets worldwide over 50,000 euros. It's a US national living in Spain as a resident. The question, let me just check it, has left those assets that are in this case, I assume it's in the US, to relatives that are living in the US. This is an example that I will explain at the beginning. Even though you inform tax office about you have a brokerage account in the US, and that account, that money is going to be given to someone who lives in the US. Whenever someone dies, which is resident in Spain and is owner of that, at the end, the beneficiary, which is living in the US, will have to make the inheritance process in the US according to that. If it's a brokerage account or any other investment that is in the US, obviously it has to be done in the US, and that will not be taxed in Spain because the asset it is not in Spain, even though it has been informed into the tax office about Model 720. Model 720, one of the big reasons is because, okay, I have a brokerage account in the US and I have some income about that, or in the UK or anywhere in the world. And then whenever you make the declaration, April, May, June of the year before on the tax return, obviously tax office needs to see that maybe you get some income on that, or maybe you're informing that income in the tax form in order to inspect you or no. Maybe it is just an information that you give to the tax office to see where it is your assets and to maybe understand where your money, your income, worldwide income may come. Okay, just briefly and to summarize, obviously. Okay. I think this from Susan is a bit confused. My husband and I are residents in Spain. The family is in the UK. We have made a will declaring the UK law applies to its contents. Therefore, the heir who is resident in the UK will pay inheritance tax in the UK and have no liability in Spain. Well, I think we have explained that, and also Michael and myself, we try to explain this. We understand it's a little bit confused sometimes, but obviously if the heirs are in the UK, but the property is in Spain, for example, or maybe the worldwide assets that are inherited to the heirs that live in the UK, some of that assets are in Spain. Okay, the Spanish asset will have to be, let's say, subject to inheritance tax, and then will be deducted in the UK. And but the heirs at the end, if the assets are in the UK and they are living there, obviously they will manage with exactly there in the UK, not in Spain. But if the assets are in Spain, they will be managed in Spain. If the heirs are living and residents in Spain, then the things change. Obviously, they is attracted to Spain tax office, and obviously we have to declare worldwide inheritance tax of worldwide assets that are inherited in that specific process. I mean, we have a lot of questions. I'm ashamed that we cannot answer all of them, but let's
I'll
go
just
to
answer
Michael.
one very quickly here because this is one that we've seen a lot now. So someone's asking here, what about an international will? Okay, so the same as we mentioned before that, I don't recommend that you make a will in the UK for worldwide assets, and therefore we have to wind up the Spanish estate using a convalidated English will plus probate. I don't recommend it the other way around either. So, for example, very often clients come to us, they've been here for 20 years, they've got assets here, they have still got assets in the UK. And what do we recommend? Okay, well, what I always recommend is you make one will in Spain for your Spanish assets, one will in the UK for UK assets. That's the gold standard. That's what you should do. Now, Does it mean that we can't do a will, an international will here? Of course we can. The cost is the same. I literally just say that on the will, the wording is, instead of it saying that it's only for Spanish assets, it says it's for worldwide assets. Then it becomes valid over there as well. The trouble that later on we're going to have to convalidate it for use in there, so it's Hague's Apostle, official translations, and various things that have to happen for it to be valid over there. Plus, you won't be receiving the correct inheritance tax advice from the point of view of the UK. Now, there is sort of a middle position here, and that is that people come to us and they say, well, you know, what do I do? I don't know if I'm going to go back to the UK or not. And we've been with you for so many years now. We just prefer that you handle it all from here. So what I always say is, okay, we'll make the Spanish will for worldwide assets. Now, if sometime between now and the next 20 years before you die, you're back in the UK and you feel up to it, go into a solicitor, say, look, I've made this will here in Spain with a safety net underneath it so that it catches anything worldwide. I'd now like to make a will in the UK exclusively for my Spanish assets. Now, later will revoke the previous one, except for if it doesn't affect that part of the world. So if you make a will years later saying it's only in reference to the UK assets, it's going to become the valid will for the UK. But if you never get around to it, we've got the will in Spain that says it's for worldwide assets, so we could always end up winding up the UK estate using the Spanish will, even though it's not the gold standard. The best thing is one will in each country where you have assets, and later on the solicitors can talk to each other about how we organise the inheritance tax and the possible combination of the bilateral agreements and things regarding that. But really, it's much easier if you've just got one will in each country. Ready to basically to go, and all in accordance with the norms in that country, and done by someone that knows how it works over there.
Okay, Michael, well, before you go, thank you very much for your time and expertise. I know you guys been practicing law very many years. You've got a lot of experience. I know it's difficult to advise generally, but all the words were very good advice. I recommend clients to organize video conference with any of your lawyers, with ourselves, with whoever, to plan ahead. There is a way for you to take advantage of all these positive comments, is knowing your specific situation for your own benefit. Now, again, you've got Michael, if you could share your email, Pedro, even though it's on screen, if you could put it here. And then you could watch back. A lot of people will be able to watch it back from tomorrow. There are a lot of outstanding issues and questions and confusion. So unfortunately, we cannot make it in 1 hour all the possible knowledge, but we really could help you to answer your questions once you provide us your specific scenarios and guide you through. Again, thank you very much, Pedro, Michael, Connie, and even one friend who's on the backstage trying to make things on time. We're going to share with you a video that you might know already. If not, I'm not sure whether we're going to be able to make another webinar because we're ready for holidays, Pedro, Michael, and Connie. So if we are, Juanfran will let you know. Thanks again for your support. We're happy to help. Have a great summer if we don't see you. Over to you, Juanfran.
When a loved one passes, it takes time to assimilate losing them. At these times, when you least want to deal with paperwork, Pellicer and Heredia are here to help. One of our lawyers will be in touch to inform you about the process and answer all your doubts on the legalities. No matter where the assets and heirs of the deceased are located, and without having to travel to Spain, we can advise you and carry out all the required proceedings in Spain. Obtain the death certificate. Search for assets, debts, and existing insurance policies. Give advice on accepting or renouncing the inheritance in Spain. Hand over information on all the related costs. Pay all the compulsory taxes on your behalf, and translate all the legal documents required. And remember that upon death, when carrying out all these processes, legal deadlines apply. Through this difficult time, when you most need help, Pellicer and Heredia is with you every step of the way. Pellicer and Heredia, international lawyers.